Yes, sir.
My Lords. With that, I was going to turn to Aerotel, which I can take reasonably shortly. The approach is set out in our written case, paragraphs 103 to 104. It's at the bundle on page 57. And you'll have seen that in the papers in several places. The additional point I wanted to just make sure my Lords have picked up in respect to step 4 specifically is the rider, which you find set out in at the end of paragraph 101 of our written case, page 57 of the bundle. And for your notes, it can also be found in Aerotel at paragraphs 26.2. The rider, you see at the top of the page, the rider is that novel and inventor purely excluded matter does not count as a technical contribution. So that is ruled out. And the Court of Appeal included the rider in Aerotel so as not to diverge from the earlier decision of the Court of Appeal in Merrill Lynch. Now, if my Lords have my case open on that page, so you can see the steps in Aerotel at 103, I'm going to pick out 5 points, and they broadly match up to the points set out in 106 to 110 of my written case, and I'll give you the references as they come up. Now, but first I'm going to start with a general observation about Aerotel, which is that Aerotel runs together questions of the identification of the invention and of its patentability over the prior art. The reasons we've been through, we say that that is inconsistent with the structure of the EPC and the Act, and inconsistent with the twin hurdle analysis of the European Patent Office. Second, we say there's a further problem that this raises, which we mention in our paragraph 107, which is that the nature of that which constitutes prior art is defined differently for novelty and for inventive step. It's broader for novelty. But there's no definition in the statute as to which of these approaches, or some other, you should apply to the assessment of the invention at all. So you're left in a quandary, and that, we say, tells you that the legislature was never intending that the prior art should be relevant for the question of identifying the invention, and that obviously then ties in with my first point about the structure.
This is the criticism that the European board has made, isn't it?
Sorry, my Lord.
It's the criticism that the board has made of Aerotel.
Taking my big denouement from me, my Lord, but indeed, all these points are ones that are set out in Dunn's in paragraph 12, seriated, and expressed in robust language. The third point about Aerotel is Aerotel contains this express rider that and it's explicit, the novel, inventive, excluded subject matter does not count as a technical contribution. We say that is strictly contrary to the analysis in G119, which says that such features must be taken into account where they interact with other features so as to contribute. That's the point we make in paragraph 109, and we say those are strictly in conflict. The fourth point is that Aerotel is a subtractive process, and in particular strips out features which are old or obvious in step 2 before it goes on to consider the exclusions in step 3. So this fails to have regard to the invention as a whole.
Sorry, can you just run that one past me again? 4.
Yes. Aerotel, if it helps, well, it's in 6, 8, and 9 of ours, but Aerotel is a subtractive process in that it strips out what is old and obvious in step 2 before it goes on to consider the exclusions in step 3. So it fails to have regards to the invention as a whole, which the EPO says one must. And it also, therefore, fails to have regard to interactions properly, Because if you strip out features before you come on to consider the exclusions, you strip out the opportunity for interactions. And I mentioned this to my lords before the short adjournment. If one thinks about VICOM, as we've been through, the European Patent Office say that VICOM, the clever algorithm implemented by a computer, interacts with an external file and provides an invention which is a better method of analysing digital media files. Under Aerotel, the file and the computer are stripped out. You can't have an interaction because all you've got left is a computer program, and that is just a computer program once you ignore the interactions. So VICOM highlights the differences between the EPO's approach and Aerotel. And you can see it in this case as well. If I can show my lord, my learned friend's written case, when they start looking at questions 3 and 4. I've already shown my lords 104, but if I can take you back to it in page 113 of the bundle. Of the bundle, paragraph 104. Known common or garden features such as conventional database networks, user device and like can form no part of a properly determined contribution. We say that's completely wrong. One has to look at the invention as a whole at the right level of generality and consider the interactions. You see something similar in paragraph 115 of my learned friend's case on page also 115 of the bundle. There you see in the third line, they strip out the ANN. They don't strip it out and say, well, we've considered this as a non-technical feature, and having looked at interactions, we've come to the conclusion it doesn't interact with other features so as to contribute to the overall invention. They just say it doesn't count. You also see it in the Court of Appeals analysis. If I may show you 75 of the Court of Appeals decision, which is on page 161 of the bundle. On page 75, it's really just the first 3 lines, and this is where they either miss out or reject our appeal question 4. But they say, subject only to the step of sending the recommended file to a user. The whole of the remainder of the contribution consists of a program, and the mere involvement of a computer does not help. They don't go on to ask the questions that G119 and VICOM say one must. They just say, it's a program, it doesn't help. And what's more, in this analysis, they strip out all of the other features. There's no discussion, despite this was put before the Court of Appeal. My learned friend doesn't, we mentioned this in my written case, my learned friend doesn't contest that. Before the Court of Appeal, we said the starting point was, as set out in question 4 in this case, the system as a whole with a database and a computer and an external file and an inputted and an external file sent out. The Court of Appeal ignore all that because they say, to reflect a question rightly from my Lord Justice Kitchen at the beginning of today, those are old, so they don't deal with them. So you see the problem. They get stripped out because they're old and you can't look for interactions. And the final point about Aerotel, my 5th point, this is set out in R110, is that step 4 invites getting into a mess about what technical means. As I set out to, my lords, under the European approach, technical is defined in G119 to mean without the excluded subject matter and therefore non-technical within the excluded subject matter, and it's just a shorthand for the actual statutory test. So I should have said as such within that sentence, but you'll get what I mean. But in step 4, how Aerotel works is you ask in step 3 the statutory question, although at that point already wrongly cast because you stripped out certain features under step 2. But then step 4 appears to ask, or at least countenance, something further, a wider roving inquiry into whether the invention that passes step 3 is still not technical. But step 3 is a statutory question. So once that's been answered, step 4 should never add anything. But by taking step 4 and asking step 4 after step 3, it invites the conclusion that step 4 encompasses something in addition. And you'll have seen in 112 of my written case, there are a number of statements from the courts in this jurisdiction querying the meaning of technicality, how it applies, and there's the fairly trenchant statements from Lord Justice Lewison saying that instead of arguing about what the statute means, we argue about what the gloss means. But in fact, if one understands it properly and one understands what the European Patent Office is doing, technical and non-technical just means within excluded subject matter as such or outside excluded subject matter as such. But structurally, as I said, step 4 appears to count.
Is there nothing non-technical that comes outside the stated exclusions?
Is there nothing non-technical that comes outside the stated exclusions?
I'm just thinking whether there's an undistributed middle.
I think there is and there isn't, and let me I'll answer that. If something is in the exclusions, it's non-technical. If something is outside the exclusions, it's technical.
Well, that's your case.
So that's my case. But the excluded classes the exclusions do permit the discovery, if I can use a sort of archaic legal language, of new excluded classes. They are say include or such as. So one can find new excluded classes if one wants to. But that's not this case. Nobody said there's a new class here. It's about computer programs. So the undistributed middle, as it were, is one might, if somebody claimed a method for politicians to make morally sound decisions, that might be a mental act. There might be something one could conceptualize which actually, properly considered, ought to be considered a new class of statutory exclusion, and they can be, as I said, discovered. But subject to that point, I say there is no middle ground. And that's what G119 says. It says technical means, or non-technical means excluded subject matter. That's why that's an important definition, and I'll show you more. But you see also how that ties into the analysis of the board, linking together the mandatory for any inventions in any field of technology and Article 27 TRIPS with the exclusions. That's how it all fits together as to form a structural whole. Now, I was going to come on to Duns, if I may, as well, because all these points are set out in Duns, and that is...
Can I just come back at you slightly on this technical, non-technical point? I think you've sort of conceded that the express exclusion of exemplary in 52.2. But I thought the real exclusion of the non-technical was more because it didn't fall within the all-encompassing provisions of 52.1, namely granted for any invention at all levels of technology. In other words, it's only if it's technical that it's included at all.
I think we are probably saying the same thing, my lord. I think I would agree.
Well, we might be, but
Subject to somebody poking me, I think that's right, because, and this is where you get the interaction between the language that my lord was just referring to, which is in Article 27 TRIPS on the one hand and the exclusion on the other. The exclusion to be understood as not excluding any patent in the field of technology. If one claims something that wasn't in a field of technology at all,
then it wouldn't be patentable.
Then it probably wouldn't be patentable.
It wouldn't be an invention, even though it wasn't listed in the exclusions.
I think that is right, although one would have to think quite carefully about the facts of any situation where that might arise, but I think that's right. But what we have seen in the context of computer-implemented inventions are the typical examples of technicality and technical inventions being inventions that relate to the analysis of digital media files. We see that in Vicom, we see that in protecting kids is another one. Other typical features are the outputting of out of files and data information. You see that again in Protecting Kids, you see that in the GEM styles referred to. The involvement of databases and hardware like that are all classic technical examples, and these are the kinds of things that are referred to in those passages in G1 19, 85, 86 and 88 that I showed now. So I accept my Lord's premise, but I don't think it really arises on the facts of this case.
No, it may not, but I'm just looking to get a sort of generally reliable, workable understanding of how Article 52 works, rather than just for the confines of this case.
Yes, indeed, and my submission is really important to understand how the structure works as a whole.
Yeah.
So, sorry, unless my Lord Briggs has... Could I turn to Dunn's then? So it's paragraph 12, which is on page 995 of the bundle.
And where is this referred to in your written case, Mr. Jackson?
Can I just get my learned friend to give me that? 63 onwards, apparently, my Lord.
Thank you.
So, paragraph 12, the first paragraph, the views of this this view is entirely consistent with the legal concept of invention applied by the board in the context of 52.1 and 52.3, which should not be mixed up with the layman's understanding of invention as novel and often also inventive. These are two very different concepts. So here they're distinguishing between the invention and the patentable invention, to put it in more strict words. The next paragraph, the technical effects approach endorsed by Lord Justice Jacob and Aerotel, seems rooted in the second ordinary meaning of the term, a practice which may be understandable given the shape of the old law, but which is not consistent with the interpretation of the EPC. So this is the Aerotel mixes it up point. The next paragraph about the insurmountable different difficulties, see that's on the third line, that's the point that I was making, that it's not that novelty and obviousness have differently defined state of the art, and there's no definition for the invention, so it leaves one in a quandary, and we submit the quandary suggests that that makes is emphasising the legislative intent that one shouldn't have regard to the state of the art when considering the invention, identifying the invention. Over the page, under 13, the first paragraph picks up the problem that I've set out with regard to the rider, that novel and inventive purely excluded matter does not count as a technical invention. And as they point out, that's inconsistent with the European law. And then at the bottom of that page, about two-thirds of the way down, you've got the paragraph starting, in fact. In fact, a non-technical feature may interact with technical elements so as to produce an effect, etc. So it's making the point I made that Aerotel misses interactions. And we would agree with all of that analysis. The other related point that I'd like to mention is that this also reflects the practical experience of the interveners, who say that in practice, the two approaches give different results. And if I can show my Lord's two references, firstly their paragraph 8.4 on page 134. If my Lords just read that, 8.4, and you'll see in the second sentence, they say the experience of CEPA and IP Federation members is that different approaches between the IPO and EBO can lead to different outcomes, and for some inventions, the choice of filing office can make a difference between success and failure. And one sees the same in their paragraph 1019 on page 141.
Do they give a worked example?
Sorry?
Do they give a worked example?
They don't give a specific example, but if you want, but my Lord, I gave Vicom as a worked example. And certainly, as you'll appreciate, I've outlined what we say are the substantive differences, where the substantive differences arise in the Aerotel approach by missing out steps and interactions and the rider, etc. So really what I'm saying about 8.4 and 10.19 of the interveners is this is the practical effect of the theoretical differences that I've identified in my written case and already before my Lords.
And it's your submission that it would result in a different, or could result in a different outcome in this case.
Indeed. And you see that in a sense, my Lord, by the fact I've shown you that in the arguments and in the Court of Appeal's decision, they just strip stuff out without identifying the invention, looking at the contribution, etc.
And just to be absolutely clear, the invention is, you say, identified at page 209, paragraph 53 of the hearing officers.
Yes, that's the
invention.
That's a summary of the invention, as it were. But yes. So the difference.
Well, just to be absolutely clear, that is the only summary upon which you rely.
That's correct.
Yeah.
And so just to be, the reason I slightly pause is because the VICOM approach is sort of a top-down approach of summarising the invention, the technical features of the invention, the features which contribute, the technical character of the invention. And that's a sort of top-down analysis which you see in 53. G119 requires a slightly more technical looking at the individual features of the claim and considering one by one whether they contribute technically. For the purpose of the arguments before my Lord, we rely on paragraph 53 and we say there's no substantive difference, but just to make clear that there's a sort of analytical approach in that one. So my Lords, that's my submissions on question 1 and error term. I've explained to my Lords how the European approach is very simply based on the structure of the statute itself. I've explained where any hardware comes into that. I've explained the intermediate step between the two hurdles, where one has to then construe the invention to identify the features that contribute as a whole, and then one has to take that through into the question of inventive step. And I've shown, my Lord, where theoretically and in practice, or where theoretically differences arise between Aerotel and the European approach. And I've shown you that in practice, that's what the interveners experience. As I said at the outset, we say even if there isn't a difference in substance, and even if it were to be the case that necessarily the two results give the same outcome in every case, this court should align the two as a matter of form. And in part, we say that as a matter of generality, but we say it's a fortiori given the slightly intemperate languages found in Aerotel and Duns and others. But we do submit that there are substantive differences which raise or risk raising substantive different results. And if that is right, then this court really must, we submit, align with the EPO. With that, I was going to go on to question 2, program for a computer.
How would it affect ongoing current cases in this jurisdiction if the law and the approach was changed?
Well, it may have a substantive effect on ongoing cases because
Yes.
things that would otherwise be refused may well be grantable upon the correct application of the law. So I don't know if that's an answer to my Lord's question. But it's inherent in the fact we say there are differences, that will have a difference, that will lead to a difference in outcome for cases being prosecuted before the European Patent Office and also in in the UKIPO and also obviously in litigation.
I mean, you say we just have the usual retrospective effect, in this case, back to the convention, not 1189.
Sorry, my Lord, said
Well, you say we'd have if we were to, as my Lord described it, change the law, it'd have the usual retrospective effect because we were declaring what the convention has always meant.
Sure.
Yeah.
Sure.
But in the light of the developing understanding of the EPO now confirmed by the enlarged board as to what it means.
Exactly.
Yeah.
Exactly.
And has always meant.
And has always meant.
Including before the added words in...
Before EPC 2000.
Yeah. Yeah.
And that's why I made the point about... Well,
Yes.
2 points. One, I referred to the IBM case on that, yes. My Lords, program for a computer. for orientation, you'll find the proposed construction in paragraph 151 of our case at 68 of the bundle. Now, the question before your lordships is as to the meaning of programme for a computer under the Act and EPC. As these arguments have been developed, that involves interaction of the meaning of computer, programme, and also instruction. As set out in the main case, in the written case, the main debate before this court is essentially whether this court should construe the terms computer and programme for computer conventionally, in accordance with a conventional computer and a conventional computer programme, or whether they should be construed in a substantially wider manner. As I understand my learned friend's case, not least his paragraph 40b, he doesn't dispute that our construction is that conventional one of a conventional computer and a conventional computer program. And although we say that construing an act in accordance with that which is conventional and the normal use of that language is a strong starting point or indicator of the correct construction, our case is not only based upon that fact. Rather, as you'll have seen from the written cases, we refer to the dictionary definitions, we refer to the English case law that we've referred to there, and we also refer to EPO case law and the guidelines, the EPO guidelines and case law books. And I'll address those in a little detail shortly, since in this area too, we submit the consistency with the EPO should be sought. My learned friend doesn't dispute these dictionaries, the English cases, or propose any counter-references, save for saying that they are conventional. And just to make an obvious point, by conventional, it doesn't mean they only just encompass desktops and laptops. But these descriptions also encompass any computer with a central processing unit, etc. So that covers mobile phones, tablets, processors in high-end washing machines and fridges, even the tiny little things stuck under the gold contacts on your smart cards. There's little computers under there. And at the other end of the scale, massive supercomputers. So it's conventional, but it is very broad. Now, against that case, my learned friend, in fact, advances almost nothing, just by way of a positive case. He doesn't set out in his written case any policy reason why a wider construction is needed. He cites no other dictionary definitions to support a wider construction. He cites no English case law. He does rely on a little European case law, but I'm going to come and show you that doesn't actually support his case. And in fact, is consistent with mine. And further, as both we and the interveners point out, my learned friend's construction captures within the, or would capture in the exclusions, a raft of things which on no reasonable basis could, we submit, be considered a computer or a program for a computer under the Act. So we say it leads to absurdities, and these are the smoke detector, mechanical oven or electromechanical oven, digital filter. Those are all traditional technologies. But also you have to bear in mind is that if those technologies were to be caught within the exclusion, it would risk infringing against Article 27 of TRIPS, because those are, we would submit paradigmatically, inventions in the field of technology, smoke alarms and filters. Now, with that outline, I've set out my case in some detail from 141 in our written case, but I don't propose, subject to any questions, my lords, to go through that, save to look at the EPO aspects.
That would be helpful. Certainly for my part, it would be instructive to see how the EPO has approached these sorts of systems.
So we've got two strands to that. First, the EPO construes program for a computer in the same manner as we do, namely a series of instructions for a computer, and therefore in accordance with the conventional usage, and I'll show you this in a moment. And secondly, we note that where the EPO does object to an ANN, it doesn't do so under the program for a computer exclusion, But if it arises at all, it's under the mathematical method exclusion.
These are all just illustrations of the broader exclusion, are they not? One doesn't have to fall necessarily specifically within the terminology of any one of the specific exclusions.
Well, that's, I think, the similar question to my Lord Briggs, which is there are other classes, you can discover other classes of exclusion.
Yeah.
But what is dangerous is to move away from the exclusions and just say, oh, just do whatever you want. The European Patent Office is very clear that the non-technical means within the exclusions as such. If there is case law which is going to develop a particular further class of exclusion, and of course the Secretary of State has, I think, a power to create further exclusions as well, then in the right case that can be developed. But this is a case about the computer program exclusions. Mathematical methods pops up at the end.
I'm thinking more the technology is developing, that the particular systems with which we're here concerned are a relatively recent development, technically, are they not?
Well, they were around before the Act, actually, and Lord Justice Burst makes that point in his judgment. So, of the 2 points I was just addressing, the first one I can pick up in our written case at paragraph 144, if I may. That's the bundle page 67. And your lordships will see the quote from the EPO case law textbook, where it says a computer program is a sequence of computer-executable instructions specifying a method, and there's a cross-reference to the Microsoft case, and you may recall I showed you the Microsoft case a little earlier on, but it says essentially the same thing. So
what is the status of this book?
Sorry, that book is a book that is produced by the European Patent Office itself so as to summarise its view of its own case law.
Right.
And it's very widely cited in the case themselves as being authoritative. And while we're on that point, we'll come on to the guidelines in a moment, my lord. And the guidelines are the second major publication by the European Patent Office, and again treated authoritative within the European Patent Office. So the definition of a computer program there as a sequence of computer-executable instructions specifying a method is consistent with our construction and consistent with the conventional usage. And then when one goes to our second point, which we mention on 120, but let me show you the guidelines themselves, please. These are in the bundle of tab 66, page 1447. And if my lords could just read the first paragraph under 3.3.1, please. And what you'll see there is the guidelines set out. That is, if there is an objection for an artificial intelligence or machine learning, it's under the mathematical method exclusion. And then in the second half of that paragraph, they summarise the law of that objection, essentially as we saw in Vicom. Namely that if you have a pure mathematical method with no external or useful function, then it's a mathematical method. But if it's applied to a practical problem, then you are okay. Now we submit those 2 points form a pair in the sense of the first point as to how the European Patent Office defines a computer program, explains the second point as to why they don't view an ANN as a program for a computer or object to it on that basis. So we do say that the European construction of program for a computer is consistent with our construction, and that's an important point to bear in mind. Now, my learned friend's responsive
So
case...
the authorities you rely upon are simply the case law of the board?
And also the Microsoft case is a specific instance of that. It's referred to in 144, the quote set out in paragraph 85.
Is The word sequence important is that the computer program operates sequentially, whereas the ANN operates in parallel.
It is one of the important points. The more important point is, so it's a sequence, so that's how a computer program operates, and there's a sequential series of logical commands which then are flashed to the CPU and cause the CPU to operate on data and memory and things. So it's a sequence, it's computer executable, and what that's getting at is that it's causing the CPU to execute those commands, and they are specifying, and they're specifying a method in that they're telling the computer what to do. And that's consistent with our construction as well, which, as my learned friend says, is conventional. And so, my Lord Stevens, you asked, are they the only ones we rely upon? We obviously refer to Gale, for example, in this jurisdiction.
Yes, I do.
But in terms of European ones,
yeah.
And the reason, but having got support from the two textbooks which are published by the European Patent Office to summarise their law, I was rather making the submission that that's a pretty good basis to start for establishing what the law of the European Patent Office is.
Okay.
Now, my learned friend's responsive case really only has two arguments of substance. Firstly, his point that our definitions relate to conventional things. And secondly, he refers to a European Patent Office case called Mitsubishi, and others that are said to follow it. Now, starting with conventional, if I can pick that up in my learned friend's case at 40b on page 92, 92 to the top of 93. And then he reiterates much the same in the end of his paragraph 41 over on page 94. So, in my respectful submission, this isn't really an answer at all. Because what is lacking there is any explanation or argument as to why this normal or conventional construction should be displaced in favour of some other wider one. The way that statutory interpretation usually starts is by starting with the normal use of language, unless some kind of indication compels the conclusion the legislature was contemplating something different. But as I've said, my learned friend doesn't advance any policy reason why, other than the conventional, should be adopted. He doesn't point to anything in the language of the Act or the EPC of the Travaux to support that. He doesn't point to any linguistic reasons or dictionary definitions. His position is just our construction is conventional. I take that as a compliment, not a criticism. And further, the interveners consider that he's wrong too. And my lords, if I can just show you that, it's on 125 of their case. Sorry, 125 of the bundle. It's paragraph 2.4. And they describe the very broad definition of computer as being inconsistent with industry usage. They describe it as technically incorrect. They describe the assertion of the weights and biases of a computer program as unexpected and inconsistent with industry usage. Now, the one case my learned friend really relies on, my learned friend relies on the Mitsubishi case, as he said, is demonstrating that the quote him in his 43 for your note, that there's no suggestion the TBA had the slightest doubt that the computer program exemption is engaged by ANNs. And he cites a bunch of other cases which he say follow Mitsubishi without dissent. And I'm going to need to address those. Mitsubishi itself is in 54 of the bundle, and if I can pick it up at page 1179, please. Now, at the very bottom of that page, you see the beginning of Claim 1 set out. And if one just looks at the first two lines of that, you see it's a hierarchical neural network apparatus implemented on a computer. So this claim recites the manner of the implementation of the ANN. It's not explained in the decision what about the invention meant that the patentee had to insert that feature into the claim. Of course, it's of some relevance when you're considering the VICOM characterization, because they're specifically citing the implementation. And what the application concerned was an ANN in which some of the layers in the network were connected with what was termed loose couplings, which are not set by training, but by rather what's called an error-correcting code matrix. One sees that in paragraphs 1 and 2, but I don't think one needs to read it. The examining division refused the invention because it was entirely general, in that it specified an ANN construction in a particular way, but without specifying any particular function or purpose of that ANN. And as you saw in the guidelines a moment ago, that's a problem for an ANN, at least as the European law approaches it, and that was in paragraph 3. The substantive analysis starts in 7, but if I can pick it up in 10, which is the bit my learned friend gets excited by, that's on 1187 of the bundle. It says a neural network relates to both programs and computers and mathematical methods, etc., etc. And he likes the words relates to. But that language is hardly surprising, because we've seen the invention in this case was computer implemented, with a computer implementation specifically citing claims. And what I'm going to show you in a moment is, just like VICOM and the VICOM, the board in this case actually was quite clear to distinguish between the ANN, which it addresses as a mathematical, under the mathematical method exclusion, and the computer implementing it. So, for example, on page 13, paragraph 13, so let me start on paragraph 12, I apologise, on page 1189. So here you see the board sets out, in paragraph 12, that the claimed neural network apparatus only defines a class of mathematical functions which is as such excluded. The neural network was purely mathematical. And then in 12.1, the board goes on to distinguish between, or says the appellant has distinguished between the claimed neural network and the computer related to its implementation. But there you see in 12 that the objection to the neural network was mathematical method. You see much the same in paragraph 13 as well. The appellant has emphasised the claim is to a neural network implemented on a computer. They say it makes the application pass the first hurdle. But then when one goes to look at the conclusions in paragraph 19, the claim as a whole specifies abstract computer implemented mathematical operations on unspecified data. And in the last sentence, its subject matter cannot be said to solve any technical problem, thus does not go beyond a mathematical method in the sense of Article 2 implemented on a computer. So we say that's all consistent. It's saying the ANN is potentially objection is a mathematical method, and the computer is a manner of its implementation. And you also see in paragraph 20, the board actually claims to point out that ANNs directed to a specific purpose are not to be excluded. So we say Mitsubishi, when you read it properly, is actually entirely consistent with the law and the case law and the guidelines. Now, my learned friend also refers to cases called Google, Bosch, and Deutsche Telekom. And if I may, I'm going to deal with these in this way, which is because I've read them all, and they do refer to Mitsubishi, but as far as I can see, they don't do so for anything relevant to this case. And I can't really work through these usefully in the time available to show them negative, but I am putting down a marker that my learned friend wants to rely upon them, and he'll have to show my lords how they're relevant and assist his case.
Google, Bosch and...
Deutsche Telekom.
Oh, yes.
So we say the EPO law, case law, guidelines, Microsoft, but even this case, are actually all consistent and support our submission as to how the European Patent Office views an A&N, and indeed construes the term program for a computer. Now, the final point we make on construction is the one about perverse results. And if I can pick these up in my written case at 162 on page 71, you'll see we set out a bunch of examples there, and the basic point we make that each of these is a device which processes information in accordance with, if you view the term instructions broadly as the Court of Appeal did, a set of instructions. And all of these would fall within the Court of Appeal's construction. But we submit none of these could properly be considered to be a computer or contain a program for a computer.
Do the words computer and program, are they related in your view? Can you have a computer which isn't capable of being programmed or not?
I think we say not, because as you see from our construction, a computer is defined as something which has a CPU and memory, etc.
Yeah.
And the purpose
So
of the CPU is
you say the two concepts are connected
yes.
in that way. You can't have,
Yes.
I mean, yeah.
I suppose there's very archaic use of computer to describe people like Ada Lovelace and such, but that's not really, I think, relevant. So the perverse points, so I'm not going to run through the examples we give. I think they're pretty clear, if I may, but I think my learned friend's response to this is his naive A&N's point, which I've developed before my lords earlier. But that argument has a number of problems for him. First, we submit this whole naive A&N's point is an artificial one for the reasons I've discussed. It requires one to try and distinguish between a component and the inherent characteristics of that component. It's artificial. But second, even if one were to go down that route, in any event, one has to consider the nature of the instructions that arise. And as I've already explained to my lords earlier, if there are instructions at all, they're instructions to the designer or the manufacturer of the A&N. They're not instructions in the sense of how that term is used in computing field, in which we've set out in 148 to 150 of our written case. The third problem with his approach here is, in any event, it applies equally to many of the examples I've already given my lords. A digital filter or smoke alarm, once designed and optimized, can no more easily or no more difficultly be viewed, sorry, that was terrible English, but be viewed as he characterized to say an A&N can be viewed. They're exactly the same. If it's right, you can cut an A&N into its topology of components and the nature of those components. You can do that for any circuit. So it's not a point of distinction over any of these absurdities, if I can call them that. So let me just, sorry, maybe and there's the other consequence of that. Sorry, I've rushed because I've already been through this once and I've cut my notes down, but the key about the second point is it's instructions to the manufacturer, not instructions for the A&N, is that accordingly, even if one adopts my learned friend's construction of computer and program for computer, an A&N doesn't contain instructions of that sort, even deploying his naive A&N example, because they're instructions to the designer or manufacturer, not instructions within the A&N of how to operate. And that's why 148 to 150, or where those become permanent, which set out the meaning of instructions in the field. And then my third point runs, which is, even I'm wrong on that, there's no distinction between that and the other absurdities. So it captures an ANN, it captures the absurdities as well. So that's really it on this point. We do submit our construction as the right one. It's conventional. It's a normal use of language. It avoids absurd results. It's supported by the dictionary definitions. It's supported by the English case law. And we say of significance, it's supported by the European case law. And we submit the court should not give in to my learned friend's invitation to depart from how Europe approaches the statute in this way also. So, what did I say? And
are you going to come back to why you say on your conventional construction this ANN doesn't qualify?
Oh, sorry, my lord. Yes, I think it's common ground. But it does, if one looks at the construction, it's 151 on page 68. Yes, my goodness, if there's a doubt about that, I definitely need to address it. 151 is on page 68 where we set out our construction.
58 or 68?
68.
68.
151 is the paragraph.
Yeah.
And so that's...
Well, 152 is where you go on to apply that to an
It's really
ANN.
152, isn't it?
Yeah.
Well, actually, and 153.
Yeah, well, yeah.
But I think it's common ground. An ANN doesn't contain a CPU. It certainly doesn't anyway. It doesn't contain memories. It doesn't have registers. And it doesn't have a sequence of logical instructions, each commanding the computer or the CPU to execute a specific logical function. It has none of that. So, the one final point I would pick up, if I may, and it's a point that my Lord Stevens raised, is about a better computer case. And we set that out in 164 of our written case on page 72. And if I can just invite my Lords to read that. So it's a short but at least potentially important point, which is, if my learned friend's case was to be correct, that the structure of an ANN is its computer and the weights and biases its program, but as soon as you characterize an ANN that way, it becomes clear the effect of the training process is to make a better and more efficient computer at each step. And just for your notes, that's how Professor Pardo described it in paragraph 24 of his report, which is in bundle page 303. He says a better computer, a better apparatus or machine at each step. You'll see then the point. If an ANN is a computer and its training is providing an improved ANN and therefore an improved computer, then the logical consequence of the controller's argument is the application remains patentable, because on his construction, training an ANN necessarily is producing a better computer. Now, my learned friend doesn't really address the substance of this in his written case. He says it's common ground below, that this was not a better computer case. But as I explained to my lords earlier today, that was common ground, but now the Court of Appeal has construed a statute in the way it has. I'm merely pointing out the consequence of that construction. So we do maintain that point, if one ever gets far enough down the rabbit hole for it to become relevant. Subject to my lords, that was all I was going to say on programme for a computer, and I was going to turn to question 4. Now, on this, we Sorry, excuse me. Sorry. On this, we've done a lot of the spade work already, and I can take this really quite briefly. But the fact I do so shouldn't be taken to indicate is not an important point, because basically at the heart of this point is correctly identifying the invention, applying the law that we've been looking at. And the other thing to keep in mind when my learned friends' submissions on this is I detect that their submissions on questions 3 and 4 actually show the tension between Aerotel and the European approach on question 1. So it's something to keep an eye on once they're on their feet. So what one has to do is one has to apply VICOM and G19, which tell us we must identify an invention properly and identify all the features of the claim which contribute to that invention. And we've seen the statement of the technical contribution, but can I just pick it up again because it's quite useful, I think, here. It's on page 209 of the bundle, 53 of the hearing officer's decision. So we know, sorry, it's page 209 if that wasn't clear. We know what the contribution is. It's a system for providing improved file recommendations. And it comprises the features and the details set out. And that passage tells us the answer to the VICOM questions. In the way that VICOM summarised the invention in that case as being an improved system for analysing digital files, digital image files, this is, as accepted by the courts below, a system for providing improved file recommendations. And that identifies the system at the invention at the right level of generality, as per VICOM. And then you can see the integers of the invention, which are set out here. So the database, that's clearly a technical feature in the sense of non-excluded, the communication network, the user device. The invention interacts at the front end with a digital media file, a physical entity, as VICOM describes it. And likewise, the output is another physical entity, the recommendation message and file. Those are all technical things in accordance with G119. Now, as to the ANN itself, if one assumes for a moment it's a computer and a computer program, which is the assumption for questions 3 and 4, it doesn't matter because that interacts at a minimum with the digital file at the front end, just like VICOM, and outputs and interacts with the real world at the back end by outputting the digital file at that end. And that's just like the kinds of interactions that my Lord saw in G119 in those paragraphs 85, 86, and 88. So we submit this as a classical example of a feature which is implemented by a computer on the hypothesis for this question, interacting with the outside world in the normal way, and it's agreed that the system is a system for providing improved file recommendations. Now, there's no question then that any of that is within the excluded classes under Article 52. And it simply does not matter that part of it is implemented by a computer program because that is not what the invention is directed to. That's just a matter of implementation. And you've seen that in the cases. This is also supported by the analysis of Sir Anthony Mann in his, just to give you the reference, in his judgment at 76. Now, there he was really considering what's now question 3, but he points out that the analysis performed by the ANN is a technical one based on technical criteria because it's analysing the technical features of the input file, even though one doesn't actually know how it's doing that analysis because it's worked out those criteria by itself by its training. And we set that out in our 175, just for your note. We also say that this is supported by the guidelines of the EPO, as we set out in our written case at 176, which is page 76, if I can ask my lords to look at that. You'll see this is a quote from the guidelines, and they are in the bundles. But it says in the context of ANNs, it says the classification of digital images, videos, or speech signals based on low-level features, e.g. edges or pixels, is another typical technical application of classification algorithms. As we note there, strictly we're like a classifier plus, we're better than a classifier, but the technical details don't matter. But that kind of analysis is a typical technical application of an ANN. Now, if I can just pick up on the question my Lord Stevens asked me earlier today about how would one assess an inventive step in this case? One would take the invention as properly identified in paragraph 53. The other thing one could do, one could run a slightly more formal G119 analysis running through the individual claim integers, but you'd get broadly to the same endpoint. Essentially, you should get to exactly the same endpoint. But one would take that invention, thus identified, having regard to the operation of the ANN, even though it's a computer program for the purpose of question 4. And you'd say, is that invention as a whole obvious? The answer is it's not obvious over an untrained, arbitrary ANN, which was a question my Lord Kitchen asked at the beginning today. And you can take this into account exactly as you did in Vicom, because again, in Vicom, the computer was well known. What was clever was the algorithm on the computer program. It had an external interaction. The whole invention formed a technical invention of analysing the program, analysing the digital file. So my Lord Stevens, I hope that addresses your question. Now, the Court of Appeal didn't really address this argument at all, and nor does the Comptroller barely engage with it. My learned friend doesn't engage with or dispute our analysis of the law under Vicom and G119. Instead, most of the argument is directed at trying to cut down the technical contribution in a way that we say is absolutely impermissible and shows the conflict with Aerotel. If my lords could just turn up how... Actually, sorry, I was going to take to 115 again, but actually I showed you that earlier, so let's not worry. But that was the example I showed you where she excluded the effect of the ANN parts themselves from the technical contribution. Why would you do that? It shows how the analysis is wrong. So that's that point. It's very simple when you understand the law. You read paragraph 53 of the hearing officer's decision, you ask the Vicom and the G119 questions, and you get your answer. If I can turn to question 3 now. I can take this one pretty swiftly too, although there's a little more to do here on one EPO case. So the assumptions we get to for the purpose of this case is that an ANN is a computer and contains a computer program, that I've lost on question 4, and so it's appropriate to carve out everything other than the recommendation file and the message, as you saw in paragraph 75 of the decision. That's what the Court of Appeal did, and we say wrongly so, but that's what we did. Nonetheless, the analysis remains very much the same as question 4. The question is whether this component or feature of the invention lies within the subject matter excluded under Article 52.2 as such. But the recommendation file are physical entities external to the computer. They exist external to the computer, as discussed in G119, 85, 86, and 88. And they're produced as a result of the operation of the system as a whole, and they interact with it, so you have that interaction. The message and file are not a program for a computer, nor are they within any of the other statutory exclusions. And so there's therefore an invention in the sense of Article 52. The claim cannot therefore be excluded. It's a very simple argument. And that too is supported by the analysis of Sir Anthony Mann in paragraph 76 of his judgment, which I referred to a moment or two ago. Now, the hearing officer and the Court of Appeal rejected this case on the basis that the benefit was subjective and cognitive. And if I can show you that, the Court of Appeal judgment at 78, it's page 162 of the bundle. You only need to read the first 3 or so lines where Lord Justice Burst is summarising the hearing officer's decision.
And is he referring there to the exclusion in 52.2b of aesthetic creation?
I will come on to that because that is what is now said. Although the hearing officer and the argument was directed to a computer program and it was rejected by the hearing officer as being a program for a computer, it's now said that the relevant objection is aesthetic creations.
Yeah.
So I will address that, my Lord, because you're absolutely right that that is what is now said. So that was how my Lord Justice Burst summarised the hearing officer's case. And then in 79, the first 5 lines, he says, I agree with that. What makes the recommended file worth recommending? It's semantic qualities, and this is a matter of aesthetics, or in the language of the hearing officer, they're subjective and cognitive in nature. What we say about all this is this is just non-statutory. This is the classic application of an untrammelled approach to the word technical, which one sees in some of the English cases, and we say is wrong in law. There is nothing in the statute which excludes patents by reference to their benefits. And indeed, my learned friend appears to accept this proposition. And if you'll note, it's in 138 of his written case. But he says the patent system does not and cannot grant or refuse patents on the basis of end-user happiness. Sorry, it's on 119. I see my Lord Stevens turning that up.
Well, there's nothing to say whether this invention does make people happier or not. That's all speculative, isn't it?
Well, no, the hearing officer's held gives you better recommendations.
Well, I thought that better for this purpose just meant corresponding more closely to semantic similarity. And whether that makes it a better experience for the user or not is unknown, isn't it?
Well, my Lord, the hearing officer does say, and provides better recommendations as a result. It's the very end of paragraph 48 on page 208 of the hearing officer's decision. He says, therefore, the invention, advantageously reflects the subject of emotional perceptions, motor files, etc., and then says, the invention is better at recognising these and provides better recommendations as a result. So I think he does actually make a finding that it's better. It may not matter much, actually, because...
Well, in 54, though, when he's talking about accuracy, which is... He's saying it makes it better at identifying and recommending files based on their semantic similarity, and at that point he's certainly not making any judgment about whether that makes it nicer experience for the user or it doesn't. I don't really know how he could make a judgment about that.
Well, I think actually that has to be read with 48, because 48 is making the point that it's better recognising, the consequence of being better at recognising these similarities is that you get a better recommendation as a result. I don't think it matters much, actually. No. I don't think it matters much. The real point is, I think my learned friend seeks to throw a bit of mud and say, well, my invention doesn't do anything, it's no good. In fact, the hearing officer says it provides better recommendations. That is the finding we had. And you'll recall, as I pointed out earlier, there was extensive argument in front of the hearing officer about this point, and he did accept these. He did accept these improvements. And you see that set out in 49. But the key point that I was just making is there's nothing in the statute which excludes patents by reference to the nature of their benefits, be they subjective or not.
The invention of a drug which delivers effective pain relief might be said to be essentially cognitive in its beneficial effect, but nobody suggests that doesn't make it patent.
No. And there's legion. I mentioned improved massage machines, better car suspension, video codecs that give you a better image on your screen for the same amount of data. Indeed, most successful inventions are successful because they give you a benefit to the user.
Is that part of the test, though, whether something's patentable or not?
No, what I'm saying is this is irrelevant. That's why I said it doesn't really matter whether it is or isn't a benefit.
Well, that's what I thought.
My point is, saying that the benefit is subjective and cognitive is just completely not irrelevant under the Act.
Yes.
It is not a ground of objection under the statute. It's not excluded. There's no class of excluded patents by reference to their benefits. So it's just an irrelevance and an error in law for that reason.
So where's the error of law by the Court of Appeal? Sorry, exactly.
The error of law is the court rejecting... Sorry, let me just read. The error of law is in the court rejecting this application on the basis that the benefits of the invention are subjective and cognitive in nature. And
unless it falls within the aesthetic.
Unless, indeed,
Yeah.
and I will, indeed, and I will address that. But it's important to understand they're talking about the hearing officer was objecting and the Court of Appeal is objecting because the beneficial effect, third line on page 78, for example, was subjective and of a subjective and cognitive nature.
And how about Yahoo then, at paragraph 5.2?
I'll come on to Yahoo, my lord.
Right, okay.
That's
We're
just
coming on to two things.
misunderstood.
Right.
I'll spend a little bit of time on that because it's put forward as having importance, but in fact it goes to a completely different type of case called a broken chain case, which is nothing to do with this, but let me show you. You see a similar analysis, though, in 81. It's a semantic similarity of the files here, which gives rise to their recommendation, but that's not a technical matter at all. And indeed, you see Lord Justice Burst there mixing up how the invention operates with its benefits. But actually here he goes further and he just gets wrong how the invention operates because the semantic similarity does not give rise to their recommendation. What gives rise to their recommendation is based solely on an analysis of the physical properties of the tracks. So drawing this together, there is no statutory objection under the Act that the benefit of the invention is subjective and cognitive. As my Lord Briggs points out, that would be true of many, many inventions, and we say that in our written case. So we say the hearing officer in the Court of Appeal referred to something which is in law, not an objection or an exclusion. Now, seeing this issue, no doubt, my learned friend in a written case does seek to find some kind of statutory subject matter to support these decisions. It's quite instructive to see where she lands. Although the objection raised by the UKIPO was that the invention was a program for a computer.
Beg your pardon, where are you now? What are you reading from now?
His notes, I think.
Oh, your notes?
Yes, my notes are, it's quicker, I can hand them up and we can all just go to the pub, but I don't think it works like that, sadly. I'm about to refer to her paragraph 127,
Right.
because the objection raised by the UKIPO was that the invention was excluded as a program for a computer, but the controller no longer advances that. And you see that in her 127.
127.
127 on page 118.
Right, thank you.
She says the appellant continues by stating that the message is at most the result of running a computer program. It's not suggested by the controller or the CA that it matters, other than for context, the recommendation is a result of a computer program. So as I understand that, there's no reliance on, for this part of the case, on the computer program exception. She says it doesn't matter. The Court of Appeal also mentioned the presentation of information exclusion in their 75, but as we point out in our written case, this invention tells one nothing about how the information is presented. And this too, my learned friend doesn't pursue. She describes it as a red herring, which formed no part of the Court of Appeal's reasoning, and you see that in her 143 on page 121. see, the appellant refers to the Court of Appeal's obiter reference to presentation of information. This is a red herring, given it formed no part of the Court of Appeal's reasoning. But as my Lord Stevens points out, the only statutory exclusion she now seeks to rely upon is aesthetic creations. And one sees that in her 135 and 136, starting on page 119. If my lords could read those, please.
So 119.
119, excuse me. 119 and then, sorry, page 119, and it's paragraphs 135 and 136.
Well, they also form no part of the Court of Appeal's reasoning, did they?
I don't think they did, my lord. But what you see she's doing is she's seeking to link the statements of subjective and cognitive benefit which were relied upon by the Court of Appeal to aesthetic creations to try and pull the objections within a statutory exclusion. Now, we might describe that as a slightly creative creation itself, but there we go, that's what's now pursued. So we're no longer, for this part of the appeal, concerned with programs of the computer at all. But my learned friend doesn't cite any law about aesthetic creations, and we submit this exclusion is obviously inapplicable for two reasons. First, the exclusion relates to, and they're related, I should say. First, the exclusion relates to aesthetic creations. And we submit you get a flavour of the correct understanding of the exclusion in the slightly extended language as it's been implemented in the Act. If I can show you that on bundle page 1460. And there, under section 1(2)(b), it's expanded slightly, say a literary, dramatic, or artistic work, or any other aesthetic creation whatsoever. We say that captures, that slightly expanded language, captures correctly what this is about. But there's no suggestion in this case that the invention is creating anything aesthetic at all. It analyses tracks physically, it sends a message with the recommendation and the recommended track. And even if the recommended track is an aesthetic work itself, the invention doesn't create it. And indeed, as we've seen from the guidelines, the EPO is explicit at classifying music based on physical features, a typical technical application for an A&N, not excluded. It's not clear how my learned friend can square a case with that either. The second related reason is that, much like the hearing officer in the Court of Appeal, my learned friend's argument here equates and confuses what the invention is and its benefits.
I mean, in a music context, it's not creating
A work of
a
art.
music file. What it is doing is selecting among a library of music files, one which will conform to the end user's perception of similarity by reference to purely objective physical characteristics.
Indeed.
Yeah.
Absolutely.
Well, there's nothing aesthetic about that at all, really.
No.
It's distressingly utilitarian. I mean, I like to think that I have some wonderfully elevated reasons for thinking that there are certain similarities between Handel and Mozart, but actually it's all to do with some terribly undiscoverable physical characteristics.
Indeed.
Yes.
So in our submission, none of that, nor the Court of Appeal's reason, nor the hearing officer's reason, stands up at all. And it was Sir Anthony Mann who got this right for the reasons that he gave. So there is simply no statutory exclusion which applies.
Where did he give those reasons? The reference?
My Lord, sorry.
Oh, the same paragraph as
Yes.
you mentioned before.
And we address that. Can you just find the reference where we address 76? We address that in our written case as well, please. Now, in our written case, we also refer to certain case law which is supportive of this analysis, and we refer at 118 of our written case to GEMSTAR on protecting kids. I don't propose to go through them now. If I can just summarise briefly, the key points are that in GEMSTAR, Mr. Justice Mann, as he then was, held there were 3 patents in issue, and he held for the 3rd patent, in that case, an external transfer of a data file was a thing external to the computer, it was not within the exclusion, and so the claims were not within the exclusions either. So he was making the same point as G119, that an interaction at the back end of this kind of computer implemented system can be a real-world interaction which can give a provider something outside the claims. So the external data transfer in that case is. In protecting kids, Mr. Justice Floyd, as he then was, he held that an on-screen alert about an inappropriate internet use would not in general be in effect external to a computer. But then he went on to say the alert in that case was different, since it was an alert message sent to a remote device over a communications network. That was an external message, it wasn't within the exclusions, and therefore the claim was allowable. And the reason I break down that description slightly is because my learned friend in her skeleton cites the bit, I think it's 34 of Protecting Kids, where Mr. Justice Floyd said that an on-screen or a typical alert would not be an effect external to the computer. But she doesn't cite the bits where he says that this one is different because it's external. It's an external message. So we say those are conventional and correct analyses of the law, and obviously on the facts similar to our own. And we also say at the end of our 119 that those are consistent with the 2 IBM decisions that we cite there from the EPO. And my Lord, sorry, just to give you that reference to where we discuss paragraph 76 of Mr. Justice Mann's decision, that's in 183 of our written case at page 77. If I can finally turn to the Yahoo case. Excuse me. Now this is, it's an odd case, I don't think this actually goes anywhere, but if you read the front end, you'll see it was an ex parte grant case, but the applicant didn't...
I'd quite like to know which page you're reading from.
Sorry? Okay, well, the Yahoo case is found in bundle 5 at page 79.
Thank you.
I'm going to... Sorry, no, that's...
No, it's 1405, I think it starts.
I'm about to pick it up at 1414, my Lord. Sorry, my head is starting to cease to function.
Right.
So just by way of introduction, before I take you to the specific paragraphs, this case concerned a computer program, rather than an ANN, which used purchase information on websites. So that's information where a website owner observes that somebody who buys object X is typically interested in Y and Z as well. It used that information to make recommendations. And the idea was that the program would make better recommendations. What one sees in paragraphs 4.5 to 4.7 on page 1414 is that the claim wasn't limited to any specific purpose, but was a general use of a mathematical algorithm. That's 4.5 to 4.7. So here you see the application of the mathematical method exclusion that we've seen already, which is something that's purely abstract, is excluded, but not when it's got a practical purpose. It was therefore rejected, but the bit that matters starts under the auxiliary request, which is the backup request in the European Patent Office. And as you see from 5.1 on page 415, you see the applicant had added a feature that the outputted item the identified item, the recommendation is outputted as a recommendation. It's not a recommendation message external to the computer, it's just a general recommendation, including just an on-screen recommendation. So that was like the first two patents in Gemstar and the on-screen alert, which Mr. Justice Floyd dismissed in Protecting Kids. My learned friend refers to paragraph 5.2. If I could ask my lawyers to play it, and then I'm going to break it down, because it's important to understand this. So as I said, it's important to understand here. And what the board is addressing in this paragraph is that an invention which has no external effect to the computer is not saved by the fact that it may cause a human user to behave differently. The fact that a better recommendation may cause a human user to do more or fewer searches is not a technical effect external to the computer, and it cannot save the claim. It's just the behavior of a human. And this kind of argument, where people say that something about a computer program which causes a human to operate in a different way and therefore end up using the computer resources differently, normally more efficiently is the argument, is what's referred to in the EPO as a broken chain case. I'll come to explain that. But the case here, 1471/08, which is SAP, is often referred to and cited by the boards for that argument. Now, that decision is in the bundle in tab 46, but I don't think we need to go to it.
So it's 174108.
1741/08 SAP, and it's in the bundle at tab 46. And the key paragraph is actually 2.1.6 in that decision, of which for your notes is on page 1037. But the broken chain cases address where an alleged technical effect is based on the actions of a human. So in Yahoo, better recommendations may cause the user to perform fewer searches and so end up using overall a smaller amount of computing resources. So the reduction in resource use is as a result of the actions of the human. But the point of the broken chain decisions is that where an alleged technical effect is based on the actions of a human, that is said to break the chain of causation and cannot be taken into account. As I said, that's 2.1.6 of SAP. I can take my lords to it if that would help. That's what's being addressed here in 5.2, and you can see that because if I take you to the summary of how this is in fact argued, if one goes to that summary of the applicant's submissions in Yahoo, it's at Roman numeral 12 on page 1410. And if my lords could just read the two paragraphs going over the top of the next page. So there's 2 points which come out of this. The first you see in the first paragraph. It's quite interesting because this first paragraph explains why the applicant is focusing on recommendation of music rather than direct marketing, which is the clear thrust of the description of the invention in this case. Because direct marketing, as it says here in the first paragraph, is a business method. Yeah. So the reason it talks about a better recommendation of music is because it's not within the exclusions. And then you see in the second paragraph, you see the patentee setting out the broken chain argument exactly as I've just outlined. They say there's a reduction in the use of computer resources because the user gets a better recommendation, so they click back on the Yahoo website less frequently. That's a classic broken chain. And as I said, I've given the reference to SAP 2.1.6. So really two things come from this. One, this case is no support for what my learned friend says, namely, all the Court of Appeal relied on it for, namely to say that there was some problem with music recommendation. Not that that's within exclusion anyway. Secondly, insofar as it indicates anything, it indicates music exclusion's fine, music recommendation's fine, that's what's chosen. So that's that case. And subject to any questions from your lordships, I was going to move on to mathematical method. I'm afraid I've hit my time, but this is probably 5 minutes, if I may. And my learned friend will...
You probably know the general rules, it comes off your reply.
Sadly. Well, it makes tomorrow easier, so maybe I should be grateful, my lord. So mathematical methods. So my lords may have picked up, well, you've picked up there's a bit of a procedural spat, but I don't need to go through that. We set out the law of mathematical method in paragraph 120 of our written case, which is bundled page 61. And if you could skim that, I've actually shown you this several times in various cases and in the guidelines. So as we set out there, the objection arises, and it only arises, where the allegedly mathematical method is divorced from any real-world purpose or application. We refer to Vicom and Halliburton in this jurisdiction. And you'll recall that Vicom said it was no objection that an invention was being described in mathematical terms, or even those terms were used in the claim itself.
Do we have any idea as to why the examining officer formed a provisional view about the mathematical exception here?
It was formally before him.
Sorry?
So it was formally before him.
Right, okay.
So...
And do you're asking us to apply your definition to the facts of this case and to exclude it. That's basically my understanding of it. And the fly in the ointment there, as far as I'm concerned at the moment, is somebody else has formed a different view.
So the hearing officer agreed with me.
So, no, not the hearing officer. That there is an application being made to the EPO, and the examining officer apparently has formed a provisional view about mathematical exception.
I think that's correct. But you have to bear in mind, in this jurisdiction, this patent was objected to by the examiner as well as being a mathematical method, and the hearing officer said it was wrong.
Yes.
So.
Right.
Sure.
But do we have any idea as to why the examining officer formed that view?
I'm afraid I can't help my
Is there any written...
it was raised for the first time in my learned friend's written case.
There are no submissions being made to the examining officer and no response from the parties in relation to that issue?
I imagine that there will have been some to and forth with the examining officer, but I'm afraid I haven't even read that.
Right. I mean, it'd be somewhat inconsistent if we arrived at one decision and the EPO arrived at a different decision.
Well, if I can break that down in two, certainly it is our case, I'm sure it's clear, that this court should align the law on all these points, should align the law on mathematical. On the exclusions, this court should align with the European Patent Office, and certainly. So if the law here was being applied differently to the law of the European Patent Office, and I was relying upon that difference to try and save my bacon here, whereas it was different in the European Patent Office, then I think my Lord's question would have some force. Now, as it is, the law is exactly the same here as it is in the European Patent Office, and that's Vicom and that's Halliburton. And I've set that out in my statement. Of course, when considering the application to the fact, human judges and examiners can come to different views. But in terms of the views, and it hasn't been argued in anything like the detail that was argued before the hearing officer, and obviously not up till this court. So it is right, my Lord is right to note that the examiner in the European Patent Office has formed a provisional view without having a proper hearing on it. But here we had a provisional view, we argued the case, and the hearing officer said we were right. And we should say that really is the starting point for this jurisdiction. And that is the starting point anyway. And I'll explain why he was right, my Lord. It's very, very simple. So the point about the mathematical method exclusion is that many inventions, or a number of points are, many inventions in physics and engineering can be described mathematically. But that doesn't make them mathematical methods themselves. And I gave the examples to my Lords earlier, in fact, of you can describe levers and cogs and mechanical inventions mathematically, you can describe filter circuits, you can describe all these things mathematically. And Vicom is the one at paragraph 8 from memory, the one that says that simply doesn't matter. And the law, which one sees set out in our case at 120, and it's never been queried by my learned friend, is that the use of a mathematical method for a non-excluded purpose gets you around the exclusion. It's a narrow exclusion. We saw that also in the guidelines I showed my Lords earlier. We actually saw it discussed in Mitsubishi when we were working through Mitsubishi for the purposes of that case. And let me show you Halliburton, actually, just, my Lord, in this jurisdiction. It's tab 28, page 704, and it's very short. It's paragraph 72 on page 704.
Not 704.
Page 704, paragraph 72.
Oh, 72, got it, yeah.
So there, as Lord Justice Burrs sets out, although it's involved with some mathematics involved, the contribution is not solely a mathematical method because the data in which the mathematical performance has been specified in the claim in such a way as to represent something concrete, a orbit design, etc. So that's just an example of, that's the example that goes into discuss scale of the application of the well-known law, which is as long as your mathematical method is applied for a particular purpose, then you're outside the exclusion. And the mathematical method exclusion is known to be very narrow. And that's why the hearing officer was right to reject this objection. And if I can show my Lord's paragraph 78 of his decision, it's on page 214 of the bundle. He says, on the exclusion of mathematical method, although an ANN and a method training an ANN is per se no more than an abstract mathematical algorithm, its specific application here as part of a file recommendation engine is, in my opinion, enough to dispense with the mathematical method objection as such. Yep. So, specific application for the purpose you see sitting in the technical contribution in paragraph 53 of the decision. My learned friend barely addresses this. He addressed it in his 32 to 33 on page 90. My Lord can skim that, but he doesn't, the important thing is he doesn't suggest that I've got the law, or indeed say anything about the law at all. I am, my Lord. Well, I can pull my case together, my Lord, in two propositions then, simply applying that law. First, the fact that something can be described mathematically does not make it a mathematical method. Whilst the ANN's this invention might, at least theoretically, be described mathematically, it does not make the mathematical methods as such. given examples of levers and cogs and things.
And anyway, you're using it for a non-exclusive.
And we're using it for a purpose.
Yeah.
And that's what the hearing officer said, and he was right to do so.
Yeah.
With that, my lords, unless you have any questions.
No, thank you very much. Mr. Nicholson.
My lords.
The lectern comes to you. In the old days, you went to the lectern.
I'm grateful, my lord.
Two lecterns.
Overrun with lecterns, my lord.
And addresses.
Thank you very much. My lords, I appear with Dr. Edward Stewart, King's Counsel for the Comptroller General. I should make clear at the outset, as we have in our written case, that the Comptroller's only concern is to ensure that Parliament's intentions are properly interpreted and can be applied in a clear and deterministic manner in the UK, giving proper effect to this country's obligations under international treaties, in this case, the EPC and TRIPS. We also make clear that as the UK's granting authority for patents, the Comptroller has no inter partes interest in whether the appellant's GB application is granted or refused, albeit that the Comptroller's position is that it was rightly refused by the hearing officer whose decision was restored by the Court of Appeal. In our written case, we divided the questions on this appeal into two parts. Part 1, comprising questions 1 and 2, are pure matters of law, which do not require consideration of the appellant's own patent application. And Part 2, comprising questions 3 and 4, are specifically about the application of the established UK approach, that's Aerotel, to the assessment of the appellant's application. Now, I'm going to address Part 1, and with your Lordship's leave, ask Dr. Edward Stewart to address your Lordships on Parts 2. We've also pointed out in our written case that within Part 1, it makes most sense to address, we say, question 2 first, which is whether the computer program exception is engaged by inventions involving neural networks. And before turning to question 1, well, that is, before turning to question 1, which is about how to apply the exclusion if it is engaged. If my learned friends are right on question 2, question 1 never arises.
Well, we're not going to leave question 1, I don't imagine, having given permission to appeal to see whether the law should be this.
I'm grateful for that indication. I'll start, however, with an introduction to artificial neural networks and what the Court of Appeal decided, and then come on to deal with the computer program as such exception. I'll pick up the mathematical models at the same time, then come back to question 1, how should we apply the exclusions in the UK? All of the interveners' points, that's from CEPA and the IP Federation, relate to the points of principle, that's part 1, and I'll seek to address those as I go along. For your Lordship's guidance, I'm planning to finish by the end of tomorrow morning, which will give Dr. Edward Stewart the first half of the afternoon, leaving the agreed time for my learned friend's short reply at the end of the normal day. So neural networks, and what did the Court of Appeal decide? The primary point on this appeal is that the Court of Appeal upheld the Comptroller's view that the programs for computer as such exclusion under section 1.2 of the Act, or 52.2c of the EPC, includes programs for artificial neural networks. And we respectfully say that it's undeniable that artificial intelligence techniques, including neural networks, are extremely important to the modern world. Just as it's undeniable that the computer has been extremely important throughout the world for the decades since the computer program exception was incorporated in the 1977 Act. When the EPC was substantially revised in 2000, the exceptions were neither deleted nor re-described. And importantly, as the Court of Appeal went out of its way to make clear in paragraph 71 of the judgment, which your lordships have at core tab 9, page 161, paragraph 71, the Court of Appeal's decision in no way holds that neural networks cannot be patented. To the contrary, the Court of Appeal is careful to explain that its decision is simply that the same criteria as have been successfully applied in respect of computer programs applies equally to neural networks and inventions using neural networks. The Court further quite rightly explains that very many patents have been granted for inventions involving or deploying computers and computer programs. Care, therefore, has to be taken with any attempt by my learned friends or the interveners to suggest that the Court of Appeal has held that the core technology or a core technology of the modern world has suddenly been rendered unpatentable. That simply is not the case. Likewise, care should be taken over assertions to the effect that it is essential that a very generous approach is taken to patentability of neural networks, for fear that the United Kingdom is going to somehow be disadvantaged in developing in the modern world. First, as the Court of Appeal made precisely clear, the same criteria is to be applied to neural networks as other computer-implemented inventions, and no one has suggested that the United Kingdom or any of the other contracting EPC states has been left out in the cold in respect of computer-implemented inventions in the almost 50 years since the exclusions have been enforced. And second, whilst it's not a matter for the Comptroller, the question as to the precise balance between enabling the free use of technology and providing 20 years of monopoly rights over new technology is a complex and multifaceted policy issue which has been very much debated throughout the world. And your lordships may already have picked up that some of the common considerations as to the breadth of the exclusions compared with the need for compared with the need for patentability were discussed in Aerotel by the Court of Appeal in paragraphs 16 to 20, pages 353 to 354 of the bundle. And this appeal is not, however, a policy debate, and the Comptroller is certainly not expressing a view as to where the balance should lie. But we do caution against assertions from the appellant and to some extent from the interveners, all of whom represent or are patent attorneys who are in the business of obtaining patents for their clients, that assertions that anything which impinges in any way on the patentability of AI must be bad. Those submissions are only looking at things from the perspective that patentability is always good. And we respectfully say that what matters for the present appeal, and we'll come on to it shortly, is that Parliament enacted the 77 Act, and it's for the courts to construe it so that Parliament's intention, and in this case its international treaty obligations, can be put into effect. To the extent that industry considers that the Parliament, and it would seem EPC contracting states, have got policy wrong, then this is not the forum to petition for change. So what then is an artificial neural network? My learned friends spent some time on this, but sliding in the views they wanted to take as they went along. It is worth us spending a little bit of time on it. My lords will have seen from the Court of Appeal's judgment at paragraphs 4 to 18, that's in Core 9, starting on page 147, that Lord Justice Burse went to some effort to explain what a neural network is, how it is constructed, and how it works. This was all based on the appellant's own expert evidence, and interestingly, no part of this appeal seeks to say that what Lord Justice Burse said was in any way wrong. But my learned friend certainly does seek to represent or reinterpret the description so as to exclude what the Court of Appeal described as an important point of detail, namely the distinction between an untrained or naive neural network and one which has been trained to perform a specific useful task. My learned friend also spent considerable effort focusing on the issue of pruning or changing the structure of a network. But note at the end of paragraph 9 of Lord Justice Peirce's judgment, the final sentence, there is a point of detail that in some systems links can be pruned too, but that does not matter. And that's an important finding, which I'll explain in some detail as we go on.
Well, some may be, but some aren't.
Sorry?
Some may be, but some aren't.
Exactly, some may be, but the issue is what actually happens.
Yes.
What Professor Pardo explained is that during training, some of the neurons will effectively not be contributing because the weights on the outputs of each of the neuron tend to zero. And if they tend to zero, you can treat them as zero. And if you're implementing the neuron in software, for example, you don't bother doing a whole series of calculations and multiplying by zero and ending up with nothing. You can ignore them, and they can be dropped from the network. What my learned friend upgrades that to significantly on this appeal is a contention that the structure of the network is changed. We say that's simply not what his expert evidence says, it's not what the Court of Appeal found, and it's not what he challenged. Everything depends on the weights and biases, and the weights and biases alone.
Certainly the penultimate sentence of paragraph 9 focuses on the weights and biases.
It does, my lord.
Not on the more general topography.
Yes. Then the final sentence is there's this extra point of detail. In some systems, links, the connections that carry the weights can be pruned, but that doesn't matter. And whilst we're on it, I may as well show you in the core bundle on page... the core bundle and Professor Pardo's report, which is at tab 16 on page 306 of the bundle. Point is at paragraph 39. Some training regimes have the potential to redefine the topology of the neural network. For example, in addition to modifying the weights and biases, neurons can be removed, pruned from hidden layers if, for example, the weights are all approaching to zero for a specific neuron, thus dynamically modifying the network structure because a neuron having a near zero weight value is unlikely to affect the output. So even though there is this detail of pruning that effectively says this neuron's not doing anything, I don't need to consider it further, I don't need to carry on modelling it. Once it's gone to zero because the weights attributed to the output have gone to zero. So picking back up with the general description, although artificial intelligence has become something of a technology frontrunner in recent years.
Sorry to interrupt you, but is an ANN a physical object necessarily? Or is it an abstract concept which is implemented in the physical object? There's a bit of a... I'm not sure where, or just it says it's machine sometimes. He says it's machine built.
My lord, we can pick up...
It says it's implemented in hardware or software.
We can pick up all of those terms. It starts on the basis of being a purely mathematical concept.
Yeah.
The moment one wants to put a pure mathematical concept into effect, one can do it through one of two ways. One can either build a piece of hardware which implements that mathematical context, or, because general purpose computers are capable, they're what we call Turing complete. They're capable of processing any function. You can always emulate a mechanical machine or an electromechanical machine or an electronic machine using a computer.
Or implement the model.
Or implement, exactly, one can think of it as directly implementing the model if one chooses.
Okay, thank you.
The Court of Appeal referred to one of the first neural networks, the Mark I perceptron, built in the 1950s. So the point that I'm making is we've known about neural networks for a long time, well before the 77 Act. It's just that in recent years, they've become they've been picked up and have the buzzwords associated that they do in the modern world.
Well, probably when you've got a lot more, I'm going to say computational without begging the question, power, you can do a lot more than you could in the 1950s.
Your Lordship is absolutely right. I wasn't going to give evidence as to that fact, but that's the reason. They take an awful lot of computational power to do very useful things, and we have a lot more now than we did in the 1950s, and therefore one can deploy these things in a much greater way.
But at the outset, you take issue then with the characterization of the training process producing a sort of modified or a more sophisticated system than simply one in which weights and biases are set at particular values.
I do, my Lord, and I'm going to show your Lordships why. We say the generic artificial neural network structure, what Lord Justice Burst called the naive ANN, is there. The training process determines the weights and biases to turn that generic ANN into an ANN that fulfills a specific purpose. And at any stage, you can pull out the sets of weights and biases frozen at the end of the training process, and you can use those just like you would a computer program in the conventional sense, loading them onto new architectures to produce exactly the same specific purpose for the loaded architecture. And we also say, my learned friend says, even taking into account elements of structure and the like, that of course the program you extract from the trained ANN must be able to be compatible with the architecture into which you load it, the generic architecture that looked just like the original untrained ANN. We say there's nothing surprising or different with that. If I write a program for an Intel personal computer, it won't run without some serious modification work on an Apple computer. Likewise, if I write for a 8-bit microprocessor, I can't just simply take the program and put it onto a 32-bit microprocessor. There's always an interaction between the architecture that a program runs on and the program itself. And the important point that Lord Justice Burst was making is once I've decided on the architecture I'm using, let's say 10 inputs, 1,024 in each of the 2 layers and 10 outputs, that's my structure. That's what I have. I train that structure. I can then take the resulting weights and biases and put them in that structure that's in its otherwise in its untrained state.
And you've used the word train. I think we used the word program. Is it your case that the program used for training is a computer program? It may not be a relevant one.
It usually is. It's a separate exercise that it's a bit like, if I may draw an analogy, there are plenty of programs around which assist a programmer in writing code, where you can pull boxes around the screen and set out the process you want and design at a very high level the program you want. You press the button and out comes the program at the end. And the program at the end is in machine code that's actually run on the conventional processor. But the fact that I've used software in the underlying program construction is an entirely separate exercise. Now, it does potentially come under consideration insofar as somebody starts trying to claim a software technique for training neural networks or something of that nature. But I think it's common ground between my learned friends and I that the training activity is required for his system, but it isn't for a part of his claim. And therefore, we don't need to get distracted by that part of the software.
Thank you. That's very helpful.
My Lords, oh, yes. Just before I sit down, I noticed the time. Your Lordships have raised on several occasions issues relating to the parallel patent application in the EPO. We do have the 2 examiners' reports, which are relatively short, relating to that, where the court applied convic in the present case. It did, as I'll come on to discuss, deal with it as mathematical method rather than computer program, but it does go through the process of applying convic. It does go through the process of dealing with the aesthetics under Yahoo. And given the submissions that are being made, that if you go down the Aerotel route, as the Court of Appeal did, the application fails, but if you go down the EPO's any hardware plus convic route, the application would be allowed. I think given the submissions that have been made, I really should hand up the 2 examiner reports in that case.
Can you do them in electronic form?
I can do it in electronic form this evening, if that would assist.
Yeah.
Also 2A, the definition by the appellants of their
Yes.
intermediate stage.
I think we're due one from you as well.
Yes, I'm aware.
Yes. Yes.
My Lords, that seems a convenient moment.
Indeed. 10:30.